This is case 12, an intellectual property fight over a VR headset. My name is Stacy Sierra, and I'll be talking about the companies in this case.
Hello, my name is Alawar, and I'll be covering the lawsuit.
Hello, my name is Corey Black, and I'll be covering the ethical implications.
Hello, my name is Ketan, Somanathan, and I'll be covering the critical thinking questions.
So, the Oculus Rift is a virtual reality headset that was developed and manufactured by the company Oculus VR. The company was founded by Palmer Luckey, and moreover, the Rift was also released in March 2016, and it enabled users to experience a virtual tourism and highly realistic games. And although the Oculus VR purpose for the Rift was to become the dominant virtual reality headset in the gaming market, it wasn't until Oculus VR was purchased by Facebook that it later had other ideas for it. So Mark Zuckerberg, Facebook's founder, had very different plans for the Oculus. So this quote kind of explains his ideas on it, but what he basically talks about is how the Oculus could have been used for other things than gaming. And what he wanted, it was to turn it into a new communication platform. However, this other company, ZeniMax, which was founded in 1986, was also very focused in gaming. It had a number of operating divisions, which included the Bethesda Game Studios, among others. And it also had a lot of intellectual properties that included The Elder Scrolls, which was an action role-playing game, and along with a lot of several successful video game franchises. Now, my partner Samra will now talk about a little bit about what happened between these companies.
Okay, so the case presented to us covers Oculus VR and ZeniMax is an interesting one addressing intellectual property. Intellectual property is legally a form of ownership for an idea presented or found. In other terms, the intellectual property serves as a title of ownership of the addressed device, idea, or product. The breach raised by ZeniMax occurred shortly after Facebook had purchased Oculus while having big plans on a new era of digital, on a new way of digital era. The lawsuit filed by ZeniMax came after the company had reached out to Facebook and Oculus VR twice, stating that any technology contributions Carmack had towards VR while he was still an employee of ZeniMax and ID Software fall under the intellectual property of the company. The lawsuit addressed not only the issue of intellectual property, but also tapped onto the NDA, which is a non-disclosure agreement, and the non-ownership agreement that covered the VR technology signed by Carmack. A non-ownership agreement is usually signed by employees whose job positions requires them to come up with new technologies and ideas. In a non-ownership agreement, the employee agrees that any discoveries and inventions made while being employed are considered the property of the employer or company, and the employee cannot claim ownership. Now, along the lines of the lawsuit claiming for intellectual property and the NDA, ZeniMax sought for financial damages for the breach of contract, copyright infringement, and unfair competition. ZeniMax claimed that Oculus, and through Carmack's relationship with previous employees at the company, was able to invite employees over to Oculus to help him fine-tune the project. That being said, ZeniMax stated that prior to Carmack's employment, he did not have the expertise needed and the know-how to create the VR technology, and that knowledge was gained through his employment with the company, which is clearly a breach of contract. ZeniMax filed a lawsuit against Oculus and Carmack on 2014, and the United States District Court for the Northern District of Texas and seeking jury trial. Oculus VR presented documents that show the company was working on its own VR technology way before, which dated back to 2010. And the NDA agreement, the non-disclosure agreement presented by ZeniMax in regards to Carmack was never finalized. Thus, it should not be enforced. On August 29, 2014, and almost 3 months after the initial lawsuit, ZeniMax amended that the case should include Facebook among the defendants, stating that Facebook intended to leverage and commercially exploit Oculus virtual reality technology, which is built upon ZeniMax unlawfully misappropriated intellectual property. Now, Facebook and Oculus attempted to have the case dismissed, but the judge disagreed, and the case was allowed to proceed to a jury that started in August 2016. During the court hearing, the court had a computer forensic expert evaluate the contents of Carmack's computer after ZeniMax stated that he had copied thousands of documents from ZeniMax's computer onto a USB storage device. During Zuckerberg's testimony, he stated that all allegations from ZeniMax Media were false. And on 2017, specifically January the 9th, the jury trial started with ZeniMax requesting $2 billion in compensation and another $4 in punitive damages. After a month, the jury found Lucky guilty and had violated the NDA agreement he has with ZeniMax, awarding ZeniMax $500 million. However, jury found that all defendants, including Facebook, Oculus, Lucky, and Orag, as well as Carmack, did not steal trade secrets. With the decision, with such decision, the court ordered Oculus to pay $200 million for breaking the NDA, an additional $50 million for copyright infringement, and another $50 for false designation of origin. On terms of false designation of origin, Arab would pay another $150 million for ZeniMax. And that takes us to the critical thinking questions with Ketan.
So our first critical thinking question discusses whether or not the lawsuit had a negative impact on Facebook and their progression into the world of virtual reality or the sale of the Oculus itself. A bit of research found that Facebook, during their lawsuit, their stocks did not drop for any significant amount, and Oculus stocks were so cheap that it didn't matter if they dropped. In fact, they were only about 10 cents at the time. However, Oculus sales also did not diminish at all, and it is still, to this day, widely considered one of the most popular VR headsets that are available. For our second question, it asks whether or not, or how to approach the issue of programmers copying or paraphrasing code from another person's work, rather than writing their own original code, and how may it be detected. Copying code is close to plagiarism, especially if it's been copyrighted, and would definitely qualify for copyright infringement based on these current qualifications. However, there is currently software that is in place to scour code and check to see if it has been plagiarized from other sources. It's used especially in schools. Currently, programs like Turnitin are very good at checking for plagiarism. So creating a database for code and for copyrighted code to check to make sure that programmers are creating their own original work and not just copying others would be very effective, and in the near future could be implemented very easily. For our third question, we were asked to do a little bit of research on the lawsuit and possibly its appeal. The jury ruled that Lucky had indeed violated the NDA, as discussed earlier, and that ZeniMax was awarded 500 compensation for that violation. However, the jury still found that the accused party were not guilty of stealing trade secrets, and in June 2018, Oculus asked the judge to either reduce the amount owed by half or to throw out the previous jury's ruling in the last case, which then resulted in the damages being owed reduced to $250 million. In December of that same year, ZeniMax then claimed that the case had reached a settlement agreement with Oculus and Facebook for an undisclosed amount. So now I'll pass it over to Corey for our ethical questions.
Hello. The first ethical question we're dealing with today is, what are the ethical implications of non-compete and non-disclosure agreements filed by large corporations against former employees? And the first ethical implication we're going to talk about is from the company to the employee. It might be unethical to fire one of these non-compete or non-disclosure agreements against an employee, because it would harm the employee's future work prospects. Even if he would go to work in a different industry, it could still be seen as a potential risk that an employer might not want to take a chance on if the employee has a former non-disclosure or non-compete agreement against them. And another ethical implication of this is it creates an imbalance of power in the relationship between the employee and the employer for the company that has the non-disclosure and non-compete agreement against them, even while they're still working there, because they both know that it's going to be more difficult for the employee to get employment after he leaves that company. So the employer kind of like has them like by the goat, and they're not going to be able to leave easily and find future employment. So they might have to do like a little bit more work or take a little bit less pay, or maybe be open to some abuse by the employer. And another thing is an ethical implication is, after the employee does decide to leave, if he has these agreements against them, the former employer can extort and like threaten legal action against a new employer who decides to hire this employee. And even if there's like no basis for the case, it's like clearly not going to be enforced, it would still discourage the new employer from hiring that employee, just because they don't want to have to pay the legal fees to deal with it. All right, and on the next question. All right, the next question, is it ethical for rival companies in the industry to poach key employees? And is it still ethical if these employees are asked to share confidential information or trade secrets? Our position on this first question is that it is ethical for rival companies to try to poach key employees. When you have an employee working for a company, they have an agreement with their employer that is mutually beneficial. The employer gets to use the employee's skills and knowledge, and the employee gets to be paid. But if a new company is coming around and is offering more money to that employee to be able to come work for them instead, and then that would benefit the new company and it would benefit the current employee. And the current company has the option to pay more to try to or give them the current employee benefits, maybe a promotion or a new job title, to try to entice the employee to stay with them. So they still are able to compete fairly with that new company. But if they try to enforce a non-compete or non-disclosure agreement or something, it would be a kind of an abusive way to keep the employee around, that where the employee is not able to use their skills to the most advantage for them. And our position on, is it ethical if they share confidential information or trade secrets? We think that it is not ethical if they share confidential information or trade secrets. Any physical intellectual property, like copyright, anything copyrighted or trademarked, or any trade secrets that are physical that you can like actually like take with you, it would be pretty unethical to share that, because that's the physical property of the former company. But just taking like yourself and your skills and your knowledge that you've built up while you've worked there, that should belong to the employee, and they should be able to employ their skills wherever they see that would most benefit them. And on the last question, should current and former employees' knowledge be protected by intellectual property law? On this question, we think no. Former employees' knowledge and skills should not be protected by intellectual property law. The reason is because they no one organization can claim that they own the knowledge of something. Knowledge belongs to everybody. So even if you have built up knowledge while working for an organization, it wasn't that organization's intellectual property in the first place. And your knowledge and skills, like if you have a contract with that employer, you're only giving them your time and they're giving you money like during that contract. But if you leave, like you take your knowledge and skills with you, that does not, like, you don't leave it behind. It does not belong to the employer. It's not intellectual property. It should not be protected by intellectual property law. And the current and the second question we're going to cover here is, are the current legal methods for controlling the spread of this information good? I think currently the methods are effective, but I don't know if they're entirely good, because I do not believe non-compete and non-disclosure agreements are good. I believe those are abusive, and they take advantage of the employee, and they dissuade competition in the marketplace. But I do think the other aspects of intellectual property law, like not being able to share trade secrets and not being able to like take copyrighted information with you, I think those are effective for keeping the intellectual property of the first company with the company and not having them lose or have their intellectual property infringed. And conclusion. And now this concludes our presentation, and I just want to thank everyone for listening.